Hello, modern European history AP students. This is something I wanted to share with you. I came across it in my research for my government class regarding the widely speculated, rumored, paranoid ramblings you'll find on the internet of this concern that somehow the elections in November will not happen, that somehow Trump will become a dictator for life. I don't know. And in researching this topic, I came across several legal scholars who pointed out that even if it hit the fan and we actually had a nationwide declaration of martial law, we still would, first of all, have elections. And I firmly agree with that. Just looking at historical precedents, we've never canceled an election in American history. That includes the 1864 election, which took place during the midst of the Civil War. Abraham Lincoln actually went out of his way to make sure the soldiers had the right to vote. You had numerous states who refused to participate in that election. So, all these concepts of states not getting their votes in, it invalidating, etc. You have a historical example of an election taking place during times that are far more volatile than the current one. So that was, something I had already thought about because I had someone ask me that, could they cancel the election? I was like, they could, I guess. I don't really think they could legally, but why would you if you pulled it off in a civil war? But people have thrown all of these wild speculations and questions out there. Getting back to what I was saying, you have historical precedents that they're going to have an election no matter what. Now, even if we didn't have an election, we would still have a functioning government, and it would not be Donald Trump. The Constitution very clearly states who is president and when their terms are done, and if there's no president, who's in charge, and if there's no president, no vice president, right? There's that whole line of succession. Now, that gets interesting, and I'm actually having my American government class read an article about it, because who would become president if we canceled the November elections is not who most of you would think it would be, because you have to do a whole lot of you have to think about the implications on the entire government, not just the presidential election. But why I am showing you all this screen right here is because in some of my research, I came upon several legal scholars who pointed out the precedents and statement by the U.S. Supreme Court in 1866 in a case or in a decision that is known as Exparte Milligan. And the reason I'm bringing this up is some of you might remember our discussion in our class about Mr. Clement Vallandingham. And this actually answers the question in the long run involving Mr. Vallandingham. Mr. Vallandingham did actually have a Supreme Court case in 1864. And the Supreme Court, conveniently in Ex parte Vallandingham, they simply sidestepped the question, in part because the way he made his case. It's a technicality. I'm not going to totally throw the Supreme Court under the bus. I'll only nudge them towards the bus. They definitely used a very strict interpretation of law and question and whatnot in that moment. And basically we're like, it was kind of like Dred Scott. They pulled the whole, we can't rule on this because this isn't really our venue. And they didn't touch it, right? Similar situation occurred, though, in 1863 in Indiana, or was it 1864? I can't remember. Regardless, during the Civil War, some fellas in Indiana were arrested for much the same stuff that occurred to Mr. Vallandingham. And they were held without trial for a while due to the suspension of the writ of habeas corpus. And they were eventually tried before a military tribunal and sentenced. Well, they appealed. And they based their appeal on a different nuance. And eventually their case made it all the way to the United States Supreme Court. where the United States Supreme Court ruled that military tribunals of citizens is unconstitutional if civilian government is still operational. They went on and on and on, and just to give you an idea of how far on and on and on they go, I mean, if you really have nothing left to do this week, you can start chewing through this. If you're curious, the word Constitution is used 127 times. It has all the ins and outs and whatnot, the arguments, the proceedings, the ruling from the court eventually, the opinion of the court, I should say, which you can just jump to if you were to click that. But long story short, the Supreme Court ruled that even though we were at war, and even though these were dire circumstances, and even though habeas corpus had been suspended, which they did actually say the president had the right to do. They said that in those extreme circumstances, the right of habeas corpus could be suspended. But habeas corpus does not forego the standard judicial proceedings per se. All it does is actually hold on the charge and the trial. It basically just allows you to be locked up without trial for an extended period of time, theoretically an indefinite period of time. So they said Lincoln had the right to do that, and Congress actually passed that. That was actually an act of Congress passed March 3rd, 1863. It was at Lincoln's behest and proposal, but regardless, they said that suspending the right of habeas corpus was constitutional, declaring martial law constitutional. A lot of things were constitutional. What they did jump to is say that a citizen of the United States not serving in the military cannot be tried by a military tribunal. For a variety of reasons, they pointed to the Constitution numerous times. They also pointed that because the civilian courts were still functional, there was no reason why the military should hold the trial, or why this man should be tried in military court and held to the military standards of justice. And it goes on, but I figured I would just go ahead and point, since we had that discussion in class, that the Supreme Court did weigh in on the topic in the long run, not actually referring to Mr. Vallandingham, but a situation, let's just call it identical. They were on trial for speaking out against the war and demonstrating against the war and this and that. They were put in front of a military tribunal, even though they were not in the military but were in fact civilians. And their conviction was overturned and their release was in fact ordered. And I will just go ahead and jump to it. The ruling of the court, I should not have jumped to it because it was back here at the bottom. Yep. Yeah, discharged from custody. And so the military commission mentioned therein had no jurisdiction legally to try and sentence Milligan in the manner. And so I figured I would just go ahead and throw that out there to try and give us a little resolution to that discussion that we had.